believe we're live.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you, Mr. Bailiff. Thank you, Miss Rhonda, Ms. Silverman. I appreciate that. We welcome the attorneys to the November 3rd, 2021 setting of the 7th Court of Appeals, appearing via Zoom. We will go on and call the docket that we have for the first case this morning. And it is 07-20-00308-CV, New Braunfels ISD versus FieldTurf USA, Inc. And the appellants, who's appearing for the appellant?
Your Honor, Brendan McBride for the appellant and cross-appellee, New Braunfels ISD.
And since you're here, I'm assuming you are ready. Is that a correct assumption?
Yes, Your Honor.
Thank you very much. And for the appellees, Carter Arnett, Mr. Bennett, you are appearing for the appellees.
Correct, Your Honor. Joshua J. Bennett on behalf of FieldTurf USA, Inc., appellee and cross-appellant.
And no doubt you are ready as well.
Indeed, Your Honor.
I know that there was some discussion about timing because there's an original appeal and a cross appeal. And we've discussed, normally our time is 20, and 5, but because there's a cross appeal, we'll give each side 20 minutes to present their case in chief and 5-minute rebuttal. So it'll be 20, 25, 5. And you feel free to present your argument in the manner you care to, logistic wise. But with that, we will go on and start with Mr. McBride. You've got the floor.
Thank you, Your Honor. Good morning. May it please the court. As an appellant, my client, New Braunfels Independent School District, has raised 2 points on appeal that relate to attorney's fees and prejudgment interest. And they're relatively small issues that aren't going to take a lot of time. I don't think, unless the court has some very good questions about them, in which case it might. But so my plan was to start actually with my argument as a cross appellee as to the points that were raised by FieldTurf, of which there are 4, really 3 or 2, depending on how you look at them. So with the court's permission, I'm going to actually start with the issues raised by FieldTurf as cross appellant. And then I'll address my 2 issues that we raised as the appellant afterwards. So let's begin with the major issue that FieldTurf has raised in this case, and it really takes the form of 3 of their issues. They're just different permutations on it. It has to do with the nature of uniform commercial code remedies as they relate to breach of warranty claims and the measure of damages. And I'll get into the details of why this is true, but long story short, FieldTurf basically is trying to take the position to get the court to agree that there really is no way to legally enforce a repair and replacement warranty. Their position is that, I guess ostensibly, although they've never come out and said it, is that supposedly you can only enforce a repair and replacement limited warranty by specific performance. There's no case law or legal authority to support that. And as you'll see when we get into these UCC provisions, that is actually quite contrary to what the UCC provides as it relates to breach of warranty claims. So let's start there, I guess, with the relevant UCC sections. The 2 important ones are section 2.714 and 2.719. And 2.714 is the default breach of warranty in the sales of goods measure of damages. And so by default, if the parties haven't said otherwise, the ordinary remedy for breach of warranty after goods have been accepted is the difference in market value. So that's the baseline default remedy. 2.719 goes on to allow the parties to specify a different measure of damages and make that the exclusive measure of damages or the exclusive remedy for breaches of warranty in the sale of goods. If they so agree that it's the sole or exclusive remedy, then the buyer is limited to the agreed measure of damages under 2.719 and cannot seek the default remedy of difference in market value unless the buyer establishes that the agreed limited warranty that the parties agreed to, quote unquote, fails of its essential purpose. And that's under section 2.719B. So there's a exception to that allows you to jump back to the default remedy under 2.714. So with that in mind, I think what gets overlooked here is that the FieldTurf refers to this phrase, fails of its essential purpose, but never really gets around to telling you what it means. And it has a particular meaning. It doesn't mean they refuse to honor the warranty. That's not failed of its essential purpose. Failed of its essential purpose, we can see this from the Dickinson case. That's that Mercedes-Benz case that both sides have cited in their brief. Failed of its essential purpose means that the warranty remedy that the parties agreed on can't be accomplished. So in Dickinson, we see an example of this from Texas jurisprudence, where a vehicle is returned repeatedly for repairs to the same parts and the parts keep breaking. And at some point, the court says there's enough of a record here to demonstrate that it was not possible to repair the vehicle. Therefore, the remedy that they agreed upon, a repair and replacement warranty, failed of its essential purpose.
Mr. McBride, can I ask you a question real quick?
Certainly, Your Honor.
Jury question number 3 that was submitted said, was the failure, if any, of FieldTurf to comply with an express warranty or producing causes of damages to your client? That appears to be a question pertaining to breach of the warranty, not what you're arguing right now. Is that right?
Right. So what we're arguing about, the big issue that FieldTurf has raised as really its first 3 points, isn't the question of the liability aspect. It's the remedy for breach of express warranty under the UCC. So what I'm arguing about now is how you calculate what the remedy is. So it's really the damages question that the jury came back with that's at issue on these points.
Does there have to be a separate submission to the jury on the issue you're arguing about now? Or is that something that is found in the absence of a jury submission just as a matter of law?
I think there would have to be a jury submission to put the actual damages award into the verdict. The question is, what should they be instructed to use as the measure of damages? So FieldTurf has, for purposes of this case, because for reasons I'll get into in a moment, they have insisted that it has to be difference in market value under these circumstances, even though there's a limited repair and replacement warranty. And we took the position and submitted to the jury the reasonable cost of repair and replacement as the measure of damages, because this field was actually replaced after FieldTurf was given an opportunity to honor the warranty and failed to do so. And that's what the jury found in response to question number 4. So there was a breach of warranty that the jury found. There was an opportunity to cure that wasn't taken. The jury also found that. And then the big issue here is, well, so what are the damages for that? And that's what this issue is all about. And I think that,
Are you suggesting that pursuing failure of essential purpose, which would allow you to collect damages, the appropriate measure of damages is reasonable cost of repair and replacement, or is it a different measure when it's a failure of essential purpose?
So if it is a failure of essential purpose, like in the Dickinson case, then it's not another remedy altogether. It's the default remedy. So it falls back to that 2.714 section that I was talking about, which is difference in market value. And I think this is really critical. What you want to do when you're looking at these cases, and it is compare Dickinson with the Rogers case and the Langford case. Those are 2 cases against Ford. And in those cases, there wasn't a showing that they hadn't or weren't able to repair the cars. But the plaintiffs in both of those cases sought difference in market value. And the court said, you can't get difference in market value, even though it's the default remedy under the UCC, because you agreed to a limited repair and replacement warranty, and you haven't established that the repair and replacement warranty failed at its essential purpose. Now contrast that with Dickinson. Dickinson, they showed that the repair warranty failed at its essential purpose. I bring all that up, but the point is, we don't have to demonstrate that the limited warranty failed at its essential purpose, because we're not seeking the default remedy. We're seeking to measure damages according to the repair and replacement warranty that the parties agreed to. To give another example, if you look at the Callaway case that FieldTurf relies on, where the guy buys the horse, and the limited warranty is, if you don't like the horse, or the horse is sick or whatever, you can bring the horse back and you get a $10,000 credit toward another more expensive horse. Okay. And the plaintiff in that case loses because they weren't seeking the remedy they agreed to and never tried to get the remedy they agreed to. So there was no breach of that limited warranty. Unlike here, where there was an attempt to get the field repaired and replaced, and it was ignored, as the jury found. So, but imagine in the Callaway case that the guy goes back. Oh, I'm sorry.
Do me a favor. What evidence is there in the record to support your proposition that you tried to get the limited warranty repair and replace and you did not receive it? Because I understand the other side, FieldTurf, arguing you never asked for repair or replacement.
They did. I don't have a list of all those citations, but there are several places where the coach was saying that, and there's internal documentation from FieldTurf where they are reflecting that they have been told that they want the field replaced. And that led up to a 2013 report that FieldTurf produced, and that they never shared with the school district, by the way, until after this dispute was into a lawsuit. FieldTurf used that report, which showed substantial degradation across most of the field, the green and the white fibers, to make a claim in their lawsuit against Tenkate, claiming that they were going to have to replace this field. So there's quite a bit of evidence that FieldTurf was well aware that they were going to have to replace the field and that they'd been asked to address the problem of the field's premature wear and deterioration. And that's what is the basis for the jury's finding, that they were given an opportunity to cure this and chose not to. Instead, what they did, consistent with the strategy that they laid out in some of their internal documents, is they upsold the district, taking more money from the taxpayers on some cleaning services to basically vacuum up the broken fibers that were all over the place. And the purpose of doing that was to keep it, quote unquote, off the client's radar, to see if they could stretch it out a little longer.
Let me jump in with a question because
Yeah.
I want to make sure I understand exactly what you were saying just then. You said they were given an opportunity to repair or replace. To me, that's a little different from saying they were asked to repair or replace and they chose not to. So I just want to make sure what the record's going to say when we go back and look at it.
The record's going to say that according to FieldTurf's own documents, they were asked by the district, by the coach, to replace the field.
Okay.
To address the premature deterioration of the field. So they understood that that's what was being asked of them at the time that they had the 2013 report prepared.
A quick question: repair and replace, and I think you intimated this in your brief. Repair and replace with what? The same or different?
With goods of like kind or quality. So in this instance, there was so much degradation. So the way that this degradation occurred is you have these long fibers that come up off the top of basically a floor mat. And then the fibers are supported by this infill material that covers up most of the length of the fiber and supports the fiber staying upright. And if the fibers themselves break down too fast, or there's not enough infill, the fibers start breaking. And so significant portions of the length of the fibers can break off until there's no more fibers sticking up above the infill.
Well, apparently this field, though, was of a certain brand or model,
Yeah.
or something like that. So it would be repair or replace with the same brand and model, or would it be something comparable? And did they have something comparable?
Well, like kind and quality. So this was a proprietary product called Duraspine that was sold by FieldTurf. So if they weren't going to replace it, it would have to be somebody else selling a similar product. And so that's what we got. We got, oh geez, what's the name of that? It's in the brief, but we had another company basically after a open public bid process and accepted the lowest bid to provide a synthetic turf like the one that FieldTurf had refused.
But did FieldTurf have a like product?
I'm sure they probably did. Sure, yeah.
Let me ask you a question about the answer to jury question number 6. It looks like the jury found that there was $100,000 benefit that your client received from possession and use of the field in the condition it was in, or at the time, I guess, in which it was delivered. I'm unclear about the time what we're talking about here. The other side, I think, is taking the position that there's got to be some sort of offset or something there on the amount of damages awarded, but maybe I'm not clear about what the arguments.
I don't think they've raised that as a point on appeal. It wasn't included in the judgment. I'm not entirely sure what the jury's thought process as to what that represented either, and that question was submitted over my objection. It wasn't included in the judgment, and I think what the jury did, and you can see it in the damages that they awarded, is they prorated the amount of the use of the field, it looks like, to reflect the number of years that it had been used. So the actual repair cost estimate, or not the estimate, the actual repair costs that were incurred was $371 or $387,000 or something like that, and the jury only awarded $251,000. And then in this other question, they awarded $100,000 for the value of the use, which under this warranty doesn't have a pro rata provision. It's just a repair and replacement warranty for premature deterioration. So I don't see a separate point where they're challenging not having that question 6 answer offset against the judgment. That's not one of their points on appeal as I've read their brief. So getting back to these UCC remedies, what you end up with is no remedy at all, because you can't have, you have to measure damages when somebody refuses to honor a warranty. So if they're not going to repair or replace it, then you do what you always do when there's a breach of contract or a breach of an express warranty. You get reasonable cost of cover, and that's your damages. It's the measure of damages under the UCC, and that's what we've agreed to. Instead of difference in market value, we have the measure of damages is the reasonable cost of repair or replacement. Not specific performance. They've never cited any case law to suggest that the only remedy for a breach of a repair or replacement warranty is specific performance. None of those cases that they've cited support that. And that's actually contrary to the UCC as well, which provides under section 2.716 that you can only get specific performance as a remedy in the sale of unique goods or similar circumstances. So, like a priceless piece of unique art or something like that. Which this isn't. This is a field that can be replaced, obviously.
And you're saying that's without regard to the agreement of the parties?
Well, that's enforcing the agreement of the parties. So if it were without regard and we were seeking difference in market value, like the plaintiffs were in Dickinson, Rogers, and Langford, we would have to establish that it was not possible to honor the warranty that was agreed to. But we're not doing that. We're actually enforcing the warranty that was agreed to, the limited warranty of repair and replacement. And so when they fail to honor that, then we measure the damages by the cost of repair and replacement that we incur. So that kind of brings me up next to the next issue then to discuss with the court, and that is the issue of the reasonable and necessary costs and whether they were proven, which is the next point that FieldTurf brings up on their appeal as cross-appellant. And let's be clear about this. The record it's in volume 7. It's on pages 140 to 142. The only thing that the district's expert was restricted from saying was that the costs actually incurred, the $371,000 or whatever it was quote unquote reasonable and necessary. But he testified about all the other facts and circumstances surrounding how that cost came to be accepted and part of the deal, and that included a open public bid process in which 7 bids were accepted, where a specialist with decades of experience in the artificial field business helped him with the technical specifications for the bid proposal or the bid solicitation, and helped analyze to determine that all of the respondents who submitted bids were able to do the work in a way that was sufficient. And the district selected the lowest bid. So that was all in the record. What he didn't get to say was he didn't think that it was specifically that it was quote unquote reasonable and necessary, the magic words. I think overwhelmingly the case law is in our favor on this, that those magic words don't make any difference one way or the other. If I came in here and said that he had said it was reasonable and necessary and nothing else, I'd lose, because that's just a conclusory statement. It's really the basis for why he thinks it's reasonable and necessary. That's the evidence. By the same token, the reverse of that logic or the inverse of that logic is true. If he doesn't say it's reasonable and necessary, that omission doesn't change anything, because the point is that's not the evidence. The evidence is, was there information from which the jury could determine that this was a reasonable and necessary cost to replace the field? And there are numerous cases, we've cited several of them to the court in our briefing, where having an open bid process is exactly how you would demonstrate that something is a reasonable and necessary cost. It's the same way you would do it if you were getting an estimate to replace your roof on your house or something. You'd get 2 or 3 different contractors and compare them to each other and make sure that they're giving you reasonable bids, which is what the school district did, and that's sufficient under the case law. So I believe that's not even a close call. I think we met our burden to establish that it was reasonable and necessary, the amount that was actually incurred. The cases that the FieldTurf has relied on are all fairly distinguishable. Like the C-Strap Pools case, they argue, well, he also said it was reasonable and necessary. But in that case, that wasn't the reason why they found it, or there was sufficient evidence. It was because there was an open public bid process. The magic words were irrelevant there, and the court says as much. So I have only a minute or so left, so let me quickly address our 2 cross points, if the court will permit. Regarding prejudgment interest, my guess is that Judge Boyer felt bad about waiting 2 years after the jury verdict was in to assign a judgment in this case, and so he decided not to award prejudgment interest. That's my guess. I don't know, because there's no legitimate legal reason for not awarding it. The problem with that is, of course, that means that FieldTurf got the advantage of hanging on to money that didn't belong to them for 2 years. And their only argument at this point is, well, they think that prejudgment interest is a type of consequential damages. There's no case law to support that argument. That's contrary to the way all courts have characterized prejudgment interest. It has a compensatory element, but it's also to encourage settlement and litigation activities that are consistent to the efficiency of the courts. And if the court would like, I can address the attorney's fees issue. I see that I'm out of time, or I can just.
You have 5 minutes. You have a 5-minute rebuttal.
Okay.
And you're free to address it at that point.
Very good. Thank you, Your Honor.
Mr. Bennett.
Mr. Chief Justice, may it please the court. There is no reason for this court to opine about why the jury was justified in not awarding any attorney's fees to the district, or why the trial court acted within its discretion when it refused to award prejudgment interest, because the district's breach of warranty judgment failed as a matter of law for 4 independent reasons. Mr. McBride has covered those 4 reasons. So let me just get into kind of the meat of those 4 reasons. The first is the district wants to rewrite the warranty that it agreed to when it took the product, it accepted the goods, and can't now undo what both the written warranty provide and the backstop function of the UCC provides. We need to remember that the UCC is operating in the background here and filling all gaps where gaps exist. And so if we look at the plain language of the warranty and the plain language of the operative statute here, 2.719, it leaves the district in this case without a damages remedy for a few reasons. Now, I want to first unpack the law and the warranty itself. The warranty is tab 3 to our cross appellant's brief. Section 2.719 is tab 5 to our cross appellant's brief. And this is how it works. Under 2.719A2, the UCC provides that buyers and sellers can enter into warranties or contracts that provides for specific remedies. And the first inquiry when you're looking at contractual or warranty remedies in this case is the remedy provided optional or exclusive? If it's optional, it's optional. That's what section 2.719A2 says. But it goes on further and says, if the parties agree that to make a remedy exclusive, it is, in the words of the statute, the sole remedy. So that's our first point. If you look at the warranty and you compare it to section 2.719A2, the district had a sole remedy here because the warranty made exclusive the remedy of repair or replacement. Mr. McBride is absolutely wrong about the district seeking that remedy.
Let me ask you this. It's been a bit since I've read your briefs. but it seemed to remember that your description of the warranty in the briefs, your quoting of it, the warranty did not say anything like exclusive or only or anything like that. Am I wrong on that? And if not, do those buzzwords have to be in it for it to be an exclusive remedy?
It has to be express, and ours is express. If you look at tab 3, which is the warranty that was introduced, it says that that from the date upon notice to FieldTurf, within 8 years from the date of completion of installation, FieldTurf will, at FieldTurf's option, either repair or replace the affected area without charge to the extent required. And then it continues on. It kind of halfway down toward the right-hand side of the paragraph, this warranty is limited to the remedies of repair or replacement. And here's the important part, which shall constitute the exclusive remedies available under this warranty.
Yeah,
and then it goes on.
I guess I did not see that additional language in your brief itself. I should have looked at the tabs. I'm sorry.
We quoted it in our facts section, but it goes on farther from that and disclaims all and any and every other kind of damages remedy imaginable. Now, here's where the district has has presented you sort of a cartoonish version of our argument. We have never said they're limited to specific performance. We have never argued that they could never, under any circumstances, obtain damages. What we said is you were limited to the remedy made exclusive under the warranty under section 2.7919A2. That's your remedy, and you never sought it. And if you want to know why they never sought it, you can look only to Mr. Brown's testimony at trial, where he and Coach Caniford's testimony at trial, the district's 2 witnesses, where they admit over and over they never asked for a replacement. They never asked for it before trial. They never asked for one after trial. 5 reporters record, 171 to 73. Coach Caniford admits he never asked. At 6 reporters record, 71 to 76, Mr. Brown admits repeatedly they never picked up the phone and asked for a replacement. They never asked for a meeting for a replacement pre-trial.
Well,
Post-trial,
counsel, that's why I asked the question I asked a while ago. My understanding of what Mr. McBride is saying is, look, we put you guys on notice that we needed something replaced. Y'all did nothing. Well, we got kids coming to school. We've got football games being played. We have to do something. So we went out and took bids and replaced it on our own. And notwithstanding the language in the warranty, we had to do something because you didn't act on it.
So 2 responses to that. One is, in the record, it's undisputed that we did replace a number of fields in Texas, and that most of our customers, you can look at 8 reporters record 229 or 313, where we say, and there's other places in the record, Brian Cox testified to this, that districts want a 2-for-1. They want to extend the life of their original purchase by taking that field as long as they can, and then asking for the replacement at a time that works for them. And then they get a second field. That's the discussion that was had earlier about a comparable replacement product for the same price they paid for the original field.
Did you discuss this 2-for-1 with New Braunfels School District?
We did not. We monitored.
So you're just assuming they would have wanted that.
I don't know if we're assuming that. I think
you wanting us to accept that would be something they would have wanted because other school districts wanted that. Let me ask you this. At the time you were replacing the fields for other school districts, did you know about the defects in the field New Braunfels School District?
So if you look at the record evidence and the reports that Mr. McBride mentioned, yes, we knew that parts of the field. If we can take a step back and just kind of look at the factual record, the issue wasn't the entire field. It was portions of the field. Small patches of the field fiber would degrade and break off. That was the issue. And so we were monitoring the field to see how much fiber, could it be replaced by patching, or did we need a full replacement? That's why we continued to visit the field, inspect the field, and monitor the field. A replacement product would have been provided had they asked for one or had we thought they wanted one at the time. That's the undisputed evidence in the record. but they never did. Now,
with regard to the other fields that you were replacing, were you replacing or patching?
for the most part, we were providing full replacements. Where patches were available, we would patch. For the most part, it was.
Is there anything in the record to indicate that this product that you're replacing elsewhere did not necessarily need to be replaced in its entirety? It could just be patched, or was
Ryan Reynolds, that's the actor. Kevin Reynolds, also Canadian. He testified that yes, patch jobs can be done and could be done, except that you monitor a field and you replace or you repair, again, at FieldTurf's option. So, but I want to get back to the law that operates in the background here. It's not that the district could never have obtained the damages.
My question relates a little bit to your statement. They never asked to repair and replace, but you knew based on your inspections that the field was degrading, and you had reports to that effect that you did not disclose to New Braunfels. You knew your other school districts were having similar problems, and apparently you were replacing fields at the same time New Braunfels was complaining about their field. And you're saying, wait a minute, King's X, New Braunfels had to ask to replace before they can invoke their remedy? Kind of like a
So our response is twofold to that. Number one, as we've cited to the court, the Becker v. Continental Motors case, it's a federal case applying Texas warranty law 709 Federal Appendix 263. There is no time is of the essence clause in this warranty. There wasn't in Becker, and there wasn't one here. So the question is, why were we obligated to repair or replace when we were everyone concedes that at the time the district replaced the field, there were 6 months left on the warranty period. There's no dispute that we could have replaced that field at any time within the 8-year period. So the question is,
there would have been no dispute that unless they asked, you didn't have to replace according to your position. You could have let the warranty expire, and then it's out of warranty. Sorry.
Well, two responses to that. That was never our plan, and there's no evidence that that was our plan. Our plan was always to replace.
Is there any evidence that was not your plan?
Correct. Eric Dollier testified.
Is there evidence that was not your plan, that if they didn't ask for replacement on the last day before the warranty expired, that you'd volunteer, we're going to replace it? Or would you have sat back and did nothing, akin to apparently upselling this maintenance product where there's a notation, some memo that indicates, well, let's tell them about this maintenance product. That way, if they don't accept it, we can kind of blame it on them for not maintaining the product. I mean, could the jury have looked at this evidence and in their view, and I'm not saying this was skullduggery, but viewed it as skullduggery, you're just trying to put them off. And now you're saying, well, they never asked for it, when there's indication that you knew the situation and you did nothing and you hid it. You hid the remedy. You hid the repair.
The unequivocal answer to that is no. And here's why. They sued us with 2 years left on the warranty period. The jury could never have been asked that question because the warranty was still valid at the time they filed suit. So before they filed suit, they had never asked us for a replacement. And there's no time is of the essence clause. We were inspecting and monitoring the field with an eye toward replacement, either when they asked or when it became apparent to us that one would be required. Or we may just sit back and say, okay, look, it's really just the end zone that's bad. We'll replace that. But we needed a holistic view of the field at the time that the decision was made. The problem here is the district sued FieldTurf with 2 years left on the warranty, then used it for another 18 months until 6 months was left on the warranty, and they replaced the field. So whether skullduggery, no skullduggery, that issue was never in this case, A, because there was no skullduggery, and B, because there was no occasion for its consideration. The district jumped the gun by 2 years. Now, I want to take that back to the UCC and explain why that's significant. We've never said that the only remedy is specific performance. That's their primary remedy that they ought to have obtained, and then were limited to a repair or replacement of the field. Now, they could have, in theory, obtained a damages remedy under section 2.719B had they satisfied the element of failure of its essential purpose. That's what this court found in Henderson, which we've cited to the court. That is a necessary prerequisite to their obtaining what the statute says under section 2.719B. Other remedy is provided in this title. Now, the district's playing a little sleight of hand here with the statutory language. They're saying because the repair or replacement remedy provided for repair or replacement, it also provided a measure of damages. That violates the statute's plain language in two ways. Number one, it elides the distinction between a remedy on the one hand and a measure of a remedy on the other. That is, a measure of damages. Damages is a remedy. Specific performance is a remedy. The specific performance is an equitable remedy. Damages is a legal remedy. So when the 2.719B says that failure of its essential purpose upon proof of that entitles remedy as had in this title, it's referring back to 2.714, which is the damages remedy for a breach of warranty. That's what this court found in Henderson, right? In that case, as in this case, the plaintiff failed to plead, prove, or obtain a jury finding on that essential piece, failure of its essential purpose. Mr. McBride misspoke when he said that we didn't tell this court what failure of its essential purpose meant. At page 22 of our opening brief, pages 21 to 22, we've pointed it specifically out in comments to section 2.719, which is failure of its essential purpose looks at not the warranty. Did the warranty fail of its essential purpose? The statutory language just did the remedy that the warranty provided and made exclusive fail of its essential purpose. And that occurs when
you took issue with Mr. McBride's characterization that this was a specific performance case. Let's
Correct.
assume that they didn't go under 2.714. Let's assume they sued for breach of warranty. What would the remedy have been available other than repair and replacement of the field?
So
under your argument.
If they satisfy 2.719B, they could have a damages remedy. If they plead it, prove it at trial, and obtain a jury finding on that issue. They did none of those three things.
That's failure of essential purpose.
Correct.
So
it's an additional element.
So the remedy would be if they wanted damages, the only way they could get it, in your view, is failure of essential purpose avenue.
Under this court's decision in Henderson and section 2.719B, obtaining damages when a warranty makes repair or replacement the sole remedy requires the showing required under 2.719B, and the district didn't do that here. Didn't obtain the jury finding.
And short of that, as Mr. McBride indicated, they weren't going that avenue. Your response would be, short of that avenue, it's specific performance. Make us repair and replace.
Short of that, if they wanted to sue for specific performance under the warranty, that's correct. That's exactly what this court held in Henderson. In that case, the plaintiff tried to raise a warranty claim, took the car in for repair, and this court said failure to plead or prove, failure of its essential purpose precluded a damages remedy. That's also the case in Langford and the other cases that we've cited to this court in our brief.
Well, let me ask you this. Is there a third option? That's the part I'm trying to figure out. If we don't have failure of essential purpose, but the defendant doesn't perform unto repair or replace, then what option does a plaintiff have other than repair or replace?
So I think in that case, you'd probably have a good case for failure of its essential purpose. If you're taking if you can show, let's just use Henderson, that this court's decision as an example, as a ready example, and slightly change those facts, and come back to Dickinson in a minute, which Mr. McBride also mentioned. But in Henderson, if the plaintiff brings the car to the dealership and then loses possession, right, use of the car, that's the substantial benefit of the bargain, right? and has to repeatedly take it in, and they're not able to repair it, they lose the value of that, that would be sufficient. In this case, what the district would have needed to show is inaction and loss of use, somehow that they weren't able to use the product.
Well, and I guess that's the question. To me, the facts are a little bit different here than that case where the car was repeatedly brought in, they were making repairs, it still didn't fix the problem. I think what the other side is saying is we brought in the car and they did nothing.
Well, I guess what I would say to that is that's not quite right. We didn't do nothing. We repaired a scene. Coach Caniford admitted that in 5 reporters' record. They also admitted that we monitored the field with an eye toward what shall we do, either repair or replace. And this is all an academic question because when they replaced the field, there were 6 months left on that warranty, and they sued us with 2 years left on the warranty. So, and Mr. Brown made it clear in his testimony that at the time suit was filed, they were never going to consider a replacement product from us. That's in 6 reporters' record, 281 to 283. Sorry, that's 125 of 6 reporters' record. So if you just follow the warranty in the UCC, yes, the damages remedy could have been available to the district had they pleaded, proved, and obtained a jury finding on it. That was their responsibility. They didn't do it. That itself is dispositive. But even if we look at the measure of damages that they did seek, now we don't think there's legally sufficient evidence of damages under 2.714B, which is the only applicable measure of damage in this case as a matter of law. It's what the UCC expressly designates as the measure of damages. But if you look at just their damage measure, replacement cost, the unappealed exclusion of their expert on that issue is dispositive of their claim. Now they say basically if we have a bid process, that is enough to prove up sufficiently reasonable necessity, and that's not true. McGinty and Mustang Pipeline by the Texas Supreme Court, and this court's own cases in Wood v. Carpet, unpublished decision, it's 2016 Westlaw 6560047. That's not enough. You can't get up and say we have a number of bids, and based on these bids, these are our replacement cost damages. So for all of these reasons, their failure to plead and prove, failure of essential purpose, their failure to prove up their own damages, the court should reverse and render.
One quick question, if I may, Chief.
Sure.
Are you in agreement with the other side that question number 6, the jury's answer it is immaterial to the issues we've got? That's the
yes,
$100,000 benefit question.
The answer is yes. Can I provide an explanation, Chief Justice Quinn?
Sure.
Okay. The reason for that question was their fraud claim. They sought basically fraud in the inducement, sort of rescissionary kind of relief. And so part of that relief was, how much use did you get out of it, right? But the jury found no on fraud, so it became immaterial after that.
The reason I was asking, it looks like the answer to question 6 was conditioned on an answer of yes to question 3, which was actually your breach of warranty, not your fraud claim. So I just wanted to make sure everybody was on the same page, that we don't look at question number 6 on the issues.
Correct.
Thank you. Mr. McBride, 5-minute rebuttal. Mute.
Unmute. Sorry. Mr. Bennett explained that he thought I was mischaracterizing his argument and then proceeded to make the argument exactly as I had characterized. The significance of this failed of its essential purpose language is really at the heart of what's going on here, and the kind of doublespeak argument that he's making. What he's talking about there is that if you agree to a repair and replacement warranty, the only money damages remedy you can get, and he just said it, is difference in market value is what he's arguing. So you can never get damages measured by repair or replacement or breach of a repair or replacement warranty, according to FieldTurf. And then when he was asked, he dodged around this a lot, but he was asked, so you're really saying if you want repair or replacement, it's only specific performance? He finally agreed after some tough questions from the court. Yeah, that's what he's saying, which is exactly what I said he was saying. The problem with that is the UCC doesn't allow that either. Under section 2.716, you don't get specific performance unless it's unique goods. So the result of it is exactly as I characterized it. FieldTurf is arguing that there is no way to enforce a repair and replacement warranty if the warrantor refuses to honor it. You can give up what you agreed to have as your measure of damages and go and get and prove it failed of its essential purpose and go and get difference in market value. And you can't do specific performance, and that's it.
Well, as with regard to specific performance, if the tenor of your contract allows specific performance, can you invoke the provision of the contract to get specific performance, even though the UCC may not provide for specific performance?
Well, I think the UCC is the governing backdrop law. So the way the UCC works is you have a measure of damages you can agree to as an alternative to a difference in market value. And you're stuck with that measure of damages unless you can prove that it fails of its essential purpose, in which case you drop back to the default measure of damages, which is difference in market value.
So you couldn't, with regard to a contract, you couldn't contractually agree to, let's say, for instance, you contractually agree to allow damages and you expressly say for some unknown reason that you don't have to prove the damages were reasonable and necessary. Now, all says reasonable and necessary is an element. Can you say that by contract you don't have to prove reasonable and necessary?
I don't know. I haven't looked at a case that says one way or the other that. I do know that the idea that you have to have specific performance for a repair and replacement warranty isn't supported by any case law that FieldTurf is citing, and they're the appellant as to that issue. So,
but your argument is just under common law notions of right to contract and enforcing the contract, that would not be enough to bind you to specific performance or give you specific performance. You'd have to look to the
I don't know how I don't know if the UCC would override that. I haven't looked specifically at that necessarily. If there had been a specific performance remedy spelled out in the warranty. I do want to address one other thing. He said that I misspoke.
If I can ask you a question related to what the chief asked just a minute ago, because here's kind of where I'm confused. Certainly, if we look at it in terms of repair, replace, and that's what the defendant has to do, then so be it. But if I'm looking at the amount of money that was initially paid for the field, you paid FieldTurf for the field. Then toward the end of that useful life of the field, you replaced the field and then got a damages of $251,000 to repair or replace. That sounds to me like the school district is benefiting from an extended period of time for use of a field for which it hasn't paid. And that's the part that I guess I'm confused about.
Well, and I'm guessing that was taken into account by the jury, because it's not just because they did prorate it. The actual cost was closer to $400,000 and they didn't award that much. And not only was it just the amount of time that was left on the field before it was replaced, but it was the fact that within a few years, this field was falling apart. It looked terrible. It was a constant headache to deal with when it was supposed to have resisted premature wear for 8 to 10 years. So we lost the benefit of many of those years in between, certainly from 2013 on, when FieldTurf knew it needed to be replaced. And I want to remind the court of a key detail.
Let me say this, I don't disagree. I think that might be the proper measure of damages instead of a repair replace remedy. And so you didn't ask the jury for what the loss of the use of the benefit of the turf was, but instead it was focused on prospectively on what it costs to get a new field. And so that's kind of where I'm trying to figure that out.
Well, the warranty doesn't have a prorate portion on it. It's repair and replacement. So that is the remedy that we agreed to. If I just may add one thing and then sum up just for a few seconds, that's all right.
Counsel,
I do want to remind the court.
Counsel, our questions kind of took you past your time. Why don't you take about a minute and sum up?
Okay, great. I appreciate that.
I know you haven't gotten your attorney fee argument either. So
no. Key fact here that I want to remind the court of, when the Chief Justice was running down all of the pre-suit or the early knowledge of the condition of this field, FieldTurf also included this particular field as part of its claim against Tenkate, saying that they knew they were going to have to replace this field. And they got the report in 2013 that they hid from the district for that purpose. So that was included in their settlement with Tenkate. It was one of the claims they were making. This field, this very field.
With regard to that, they say they were going to have to replace the field or just parts of it?
They said that they included it in their claim against Tenkate among the fields that were prematurely degrading. And in general, they had to replace those fields. He says that they could replace little patches of it, but the testimony also was that you end up with an uneven field. And when it starts degrading in patches all over the green and the white fibers all over the field has to be replaced. You can't just do a patchwork repair job.
I apologize. I cut you off a while ago. I think you were going to talk about attorney's fees, and I was going to ask you a question related to that.
Okay.
I'm trying to understand this contract that you had with your client, or at least what the evidence shows. Did you have a hybrid agreement where you received some in fees and some as a contingent fee?
No, we had a contingent fee agreement where we recover a percentage of the total the gross recovery of the client.
Okay. There was a question in the other side's brief that kind of suggested that you might be recovering attorney fees in two different ways, and I was trying to determine what that had to do with the jury's zero.
No, I think what they're trying to say is that if there is a express award of attorney's fees that was greater than 40% of the recovery, I think there's an option to receive that instead. But it's not a hybrid fee where there's a portion that's hourly and a portion that's contingent. And in any case, they're wrong about that because the attorney's fees claim, whether it's hourly or contingent, belongs to the client. So the jury's not finding that the attorney doesn't get a fee. The jury is finding and that's been made clear in Rohrmoos, the jury's finding what the client's attorney's fees are, and they have to award something. Let me just very briefly sum up what we're asking the court.
Let me do this. We've gone past the additional minute, and again, because of our questions, I will say both sides have thoroughly briefed the issues, very commendable in that measure, and we will turn to your briefs again in order to dispose of the case. So with that, why don't we shift to Mr. Bennett and give him his 5-minute rebuttal.
Thank you, Your Honor.
Yeah, I want to make clear what the district's trying to do here. They want to take a warranty that said your exclusive remedy is repair or replacement, and that further disclaims every imaginable form of damages that the district itself agreed to, and then say none of that language actually matters. And what's more, none of the language in section 2.719 matters either, because if you provide for repair or replacement, you're effectively providing the remedy that you're disclaiming. And that can't be the law, and in fact, isn't the law. It's not a difficult analysis. You track the language of the warranty to 2.719, and then you make plaintiffs do what plaintiffs always should do: prove their case. If you think you're entitled to a damages claim under a warranty that disclaims all other remedies, then satisfy 2.719B. Plead it, prove it, get a jury finding on it. And the district did none of those things in this case. What it wants to do instead.
Counsel, in answer to one of the questions Justice Doss posed earlier when he was asking if there was a third option, I guess your answer would be no. You either go damages under failure of essential purpose, and if you don't do that, then you enforce the warranty. Specific performance, pretty much.
Correct, because that's what the parties agreed to. That's what the parties agreed to. When you agree to a sole exclusive remedy, that's your remedy. All the district had to do is say, we won't accept this remedy. We want a condition, and we've cited cases to the court. Wyatt is a case we cited in our reply brief, where warranties do provide for damages as a remedy and a measure of those damages as a remedy. But that didn't happen here. Not only did it not happen, the opposite happened.
If I may, your response to a question I posed to Mr. McBride would be that it doesn't matter if the UCC says specific performance is only in limited circumstances. You can contract pretty much for specific performance.
Correct. Well, you can contract for repair or replacement. That's right. Okay. And so that's what 2.719A2 says. It can be optional, but if you make it exclusive, it is the sole remedy. And they're bound to that. They can't change it after the fact. On the damages issue, I want to be clear. The warranty's measure of damages, 2.714B, can be, is subject to exceptions. And we mentioned this in the trial court, and we've raised it again here. Special circumstances. If you plead or prove special circumstances, you can get outside the benefit of the bargain measure provided, and they didn't do it. We pointed that out at trial at several points. They never tried for a pretrial or post-trial amendment of their pleadings, and they never submitted any of that evidence. They just went forward on whatever theory they had. That is legally insufficient as a matter of law. In terms of the issue of attorney's fees, I want to touch on this, and just so I can say one thing about it. There is a hybrid fee arrangement. That's the plaintiff's exhibit 120, where they told the jury they're going to get either of two versions of the attorneys are compensated in either of two ways. So you can look at that and the testimony about that in the record. It speaks for itself. But the bigger purpose, the bigger point here is FieldTurf made attorney's fees the center point of its case. That this case was all about attorney's fees. That when the district sued for, in fact, we said that expressly, 10 Reporters Record 76 in our closing statement. If you pull back the veneer, we argued, that's why we're here, the attorney's fees. We made the utter lack of necessity of this case the center point of the defense. The jury heard all of that evidence, and it was extensive about all of the kinds of options we offered customers, not an upsell like Mr. McBride said, but a free replacement product, that we'd worked with all our other customers, that we would have done it here, that they failed to mediate as they were contractually required to do. The jury heard all of that after extensive week-long trial and found the district was entitled to nothing. And that's okay under various decisions by the courts of appeals and even the Texas Supreme Court, all of which we've cited in our brief and will rest on. The last point I want to make is the court ought to look at our reply on the utter deficiency in Mr. Kunkel's testimony about all the cases cited there, about why the cases Mr. McBride cites aren't sufficient to prove up what they needed to prove up, and highlights the prejudice that FieldTurf suffered as a result of their untimely disclosure of Mr. Kunkel's opinions. For all of these reasons, judgment should be rendered in FieldTurf's favor.
Thank you, counsel. With that, the case is submitted. We want to, well, let me ask you, do any of the judges have any questions?
I'm good. Nothing.
With that, the case is submitted. You are excused, but I want to thank you for appearing through Zoom. One of the things that this pandemic has allowed us to do is develop Zoom. And as you know, in transfer cases, statutorily required to go to the place from which the case was transferred. But this gives us an opportunity to address your case without having to travel, and hopefully to address it more timely. So again, thank you for agreeing to do it this way. And with that, we will be in recess until our second case this morning.